Second.
Oh, there you are. I can hear you
Oh, I
now.
think it was the recording thing. Okay, I'm sorry.
That's
Well,
okay.
thank you so much for having me. Have been practicing as an attorney roughly 27 years, almost all of it in investment management. Brightstar was my law firm practice, which I launched about 6.5 years ago. We serve roughly 350 or so advisors. Sort of 95% of our clients are advisors. So we focus on this space, doing work in regulatory and corporate work. So regulatory, we do registrations, compliance, program development, and ongoing management. We also represent folks in SEC exams and investigations. And on the corporate side, we do everything from helping folks to launch their own RIA, structuring sort of business arrangements with equity compensation and employment sort of arrangements, as well as doing lots of M&A, which we'll talk about today, and internal successions and private fund formation for hedge private equity and venture capital funds.
So you have your hands full. You bring a lot of experience and insight. I've heard you speak at conferences, including the NSCP. So I'm very, very honored to have you on board. Just for our listeners, today's goal is really to show RAs how their corporate structure, contracts, and compliance can impact a sale, and how advisors, the client-facing staff, can contribute, because that's something that it's probably rarely discussed and focused on. So let me start with the first question, Rich. From a legal perspective, what are the most common structural issues that delay or reduce the value of an RA during a sale?
Well, I think that buyers are typically making sure from a compliance and legal perspective that they manage risk, and one of the ways they do that is in purchase agreements. They require you to make a long list of representations and warranties that the company is operated, in compliance with all rules, laws, and regulations. And so part of that means that you have to have, sort of the legal agreements and compliance buttoned up, right? So it's important to make sure that your compliance program is well established, and that there are no sort of gaps that haven't been addressed. Client agreements can also present an issue because typically in an acquisition, you're going to have to sign the contract. And oftentimes, sort of folks have provisions that require written consent from clients, which can actually sort of make the transaction take a bit longer because they have to reach out to clients and actually get their written consent to those contracts. Now, for SEC registered firms, typically that's not a requirement to have written consent. So you can go through negative consent process if you amend your agreement to allow for negative consent. Some state registered advisors, however, have to have written consent, so that can't be avoided. The other thing is making sure that privacy policies allow for sharing of information with an
Right.
acquirer, right? Because if that is
Yep.
not in place, then you potentially have sort of issues with respect to having to, sort of get consent from clients to share their information with an acquirer, which can, sort of definitely delay the process of getting the transaction completed. Right. So,
Right.
yeah. And then on top of that, just making sure that that the client agreements don't contain any prohibited language. For instance, a lot of focus has been on making sure at the SEC level that there are no hedge clauses in client agreements that inappropriately limit firms' liability. And so those things, along with making sure you're on top of your compliance. And that there's no sort of material compliance issues are critical.
And avoid surprises as much as possible, right? Or prevent surprises.
Absolutely. Yeah.
That's the proactive role.
Yeah. I mean, and that oftentimes means making sure that you have either someone internal or someone external really doing a deep dive on the legal and compliance issues to make sure that you are buttoned up and that you can address those issues instead of having a buyer come in and you're surprised that something's an issue. It definitely sort of undermines confidence that the selling firm is in tip top shape.
Right, right. Next question that I think is something that is important to really and ties into what you just touched on in terms of how an advisor can proactively support the firm to ensure that the contracts, the client agreements, and compliance documentation are M&A ready. In addition to what you just touched on, is there anything else that perhaps you can recommend?
Well, I think it's definitely sort of following firm processes and to make sure that all the client documentation is appropriately completed. Buyers definitely focus on contracts. They focus on compliance, making sure that advisors are complying with regulations, that they're completing paperwork when they're onboarding clients. Those are definitely important to remember. But I think advisors, because they see things on the front line, also can suggest things that can enhance compliance or enhance sort of how the documents actually sort of work, right? Contracts. And
Sure.
so making recommendations, I think, is
Yep.
helpful. But I mean, I think the core of it is making sure they're following the process, right?
Right.
In terms of making sure that things are buttoned up from a legal and compliance standpoint, to make sure they've got the proper
Yeah.
paperwork in place.
And that's a very interesting point, which brings me to the next question that I have, which is tie into what you just said. They're the front line, and they can detect, and they can protect, and they can assess very quickly how they can take proactive steps. But in your experience, have you come across, or have there been circumstances whereby there might be some early warning signs in legal or operational structures, or even sales structures, that a sales team might notice are potential red flag for management? Because again, it's all about cooperation, it's all about collaboration. This is, we're all in this together kind of approach. Is there anything that the front line, the client facing staff, can say to management, hey, I just noticed this, I wanted to bring this to your attention, if you're looking into be M&A ready?
Well, I think it goes back to if they're seeing ad hoc processes, not seeing consistency in terms of how they're approaching sales, approaching
Right.
compliance, right? Whether they're seeing things that are done that are not done consistently, right?
Right.
And that's what you want to see in a firm that is more likely to sort of reduce risk, right? Process helps reduce risk. I think also at some level, when they see materials that don't look right, right? Marketing materials or other things. That's another sort of way of pointing out, like, hey, maybe these are sort of things that we're saying that may or may not be accurate,
Right.
right?
Right.
And making
Right.
sure that they have an open invitation to let folks know we need to fix these things, because it is definitely an issue, not only from a regulatory issue, but from a buyer standpoint, if marketing materials are promising things or saying things that are just not accurate.
Oh, yes, absolutely, absolutely. And if I may add something that just I drew from what you just shared so far, I think that buyers today, not only are they extremely sophisticated and cautious, and they have the right tools to make the right decision and due diligence, but they also are looking, kind of taking a look under the hood, so to speak, right? And take a look at the whole company from a holistic perspective, and see what kind of culture is taking place, and what kind of culture is there any inconsistency between what they see up front versus what they see behind the scenes. And I agree with you that at the end of the day, if somebody within the company, in that collaborative cooperative spirit, rings the bell and say, something is not, we are inconsistent, marketing focus is extremely important. Quite honestly, I hadn't thought about that, but I'm glad that you share that point, which is important. But I'm assuming, and I'm asking you this as a experienced professional. I'm assuming that culture plays a role during those even early M&A discussions.
Well, It definitely does, and I think that increasingly buyers definitely want to make sure there's a good fit, right?
Right.
And understanding, because I mean, depending on the type of buyer, I mean, there are circumstances where I mean you have to fit in when you're integrating, or even if they sort of mostly leave you alone to run your business, they want to make sure it's run in a proper way, right? So I
Right.
think it is very important to have culture. And one of the things I find that surprises a lot of sellers is how much due diligence that a buyer actually does, right? They do a lot. And
Right.
so, and they ask for a lot of representations to make sure that the firm is run in a way that does not create risk for the buyer, right? So
Right.
there's a
Right.
lot that's involved there. And I think that does surprise sellers.
Yes, I agree with you. One last question, and thank you for all this great insights. In your experience, is there a difference on how RAs, there are a different stage of growth from 500 to a billion to five, or even 5 billion to 10 or 20 billion? Is there a difference in approach on how they should be ready, or are the buyers looking at this company slightly different? Pushing aside and putting aside the legal component, the legal aspect of it, is there anything that perhaps are different because they're just in a different stage of their business and they have different experiences, for example, or is the approach, besides the compliance, and legal and operations requirements and contractor requirements, or is it just across the board pretty much consistent?
I mean, I think that there are different expectations from the types of buyers who acquire firms at different sort of levels, right?
Right.
Small firms, if you don't have an institutional buyer, maybe there's not much focus. They're basically looking to acquire the book of business, and so maybe the infrastructure is not as important. But the institutional buyers typically, they do expect a lot, right?
Right.
From an infrastructure standpoint, whether you're 500 million, 5 billion, obviously there's a lot more sort of under the hood in terms of what it is, but they expect that you're running a professional shop, right?
Right.
In a shop that follows process and has, as you get bigger, you have definitely sort of more sort of professionalized management. But at the end of the day, there are things that they fully expect to see, regardless of the size of the firm, right?
Right.
So it depends a lot on who's acquiring, but I mean, I think, you definitely want to make sure that the firm is growing in a way where its processes are adapting to its growth.
Makes perfect sense. Well, I am all set for the questions when it comes to these particular episodes. I just want to share with our listeners that we're going to have two more opportunities for to listen to Rich to get more insights. We're going to slice and dice this particular M&A process in the next two instances and episodes. In the meantime, Rich, I want to thank you so much for your time, your insights. Great listening to you as always. If listeners would like to reach out to you, and I have the slide up right now with your information, what is the quickest way, or how can they reach to you?
Yeah. Either by LinkedIn, connect with me on LinkedIn, or if you want, you can also email me. And I think Camille has my contact
Yes.
information
Yeah.
there. So
Yeah.
yeah, but either way
Yeah.
is fine. Love to engage with folks in our industry, and
Right.
I feel like it's a process where we're, at some level we're all learning, but I'd love to be a resource for folks. So happy to have folks reach out.
And that is incredibly important. I really appreciate